my dear learned brothers, sisters, advocates. So I am going to ensure that I do not become boring in my lecture. Number one, that is important most thing. So if I succeed in that, means I am satisfied that I have served my purpose today. Number two, sir, before I start on the main topic, I want to tell you one example that there are some 3-4 countries in the world like Canada, Australia, UK and USA. These are the countries where even an intern or a junior, you cannot talk to the advocate on the phone without your billing starting from your credit card. That is the position. म्हणजे कुठला क्लायंटनी तर त्याच्या वकील किंवा त्याच्या ज्युनियरशी बोलायच्या तारीखबद्दल किंवा काय कन्सल्ट करायच्या, नॉट अलाउड टू टॉक इन अ लॉ फर्म or any lawyer without money being charged. India has at least, if not 1,000 times, at least 500 times more litigation available in India, but still we have a position where lot of lawyers find it difficult to make two ends meet, as we saw in Corona times. काही वकील लोकांनी आत्महत्या सुद्धा केली होती. And I feel that we have ample potential if there is proper guidance and proper streamlining of the litigation work in India. There are some bar associations I have seen people grip, अरे काही वकील लोक आहेत त्यांना पोलीस केस देतात म्हणून आमची प्रॅक्टिस चालत नाही. I think that is a very frivolous excuse. I'll teach you how. It is not at all required to bother about that. कोर्ट मध्ये फक्त तोच सेन्शा असतो ज्याने ऑर्डर जिंकून आणला, बाकी कोणी सेन्शा नसतो. तुम्ही एक मॅटर मध्ये ऑर्डर जिंकले ना, समोरच्या कोणी असेल ना, यू आर किंग ऑन दॅट डे. सो फोकस ऑन नॉट कमिंग एम्प्टी हँडेड फ्रॉम द कोर्ट, ऑन गेटिंग ओनली ऑर्डर्स. Secondly, I practice from magistrate to Supreme Court. Every month I go once or twice to Supreme Court for big matters, and I don't ever come back empty-handed. 99.9% success I try to achieve. Now, how all these things are available to you, and the best of the richest of the courts in Bombay city are magistrates court. Now, you must be wondering how is it over here. The biggest money is available in magistrate court. How? I will tell you how. Session court मध्ये कुठले केस चालतात? Murder, rape, kidnapping, abduction, robbery, serious offenses म्हणतात त्यांना. These are some of the main offenses. Serious म्हणजे serious offenses मध्ये main हा असणार. Apart from those PMLA and the special cases आहेत. तर हे सगळं चालतात. तो लोअर कोर्ट मध्ये काय ना, the biggest of the cases which have biggest stakes involved are forgery and cheating cases. That is traveled by magistrate. And biggest money is available over there from the clients also in terms of fees. If we are able to deliver the goods and client knows this person will give me the result. And secondly, I would want that after this lecture, every advocate should be so prepared that Vikhroli court म्हणजे इथून magistrate ला ज्या court cases मध्ये power आहे ना, that cases will never get rejected or go to session or high court. This will end here only. म्हणजे इथे तुम्हाला प्रत्येकाना सक्सेस मिळाला पाहिजे अशी मी तयारी करून आणली आहे तुम्ही लोकांसाठी. I have compiled a chart of judgments. First I have given a book of judgments. This is a big compilation of 63 judgments. This is topic wise. The topics are forgery and cheating. काही judgments त्याच्यावर आहे, पेज नंबर सगळं लिहिलेलं आहे. Which are travel usually in magistrate courts. Second is of abatement to suicide. त्याच्यासाठी बेल किंवा ABA पाहिजे. त्यासाठी how easily you can obtain bail and ABA. Those judgments are there with page numbers and para numbers also marked. Then there's another, the single page चा chart आहे इकडे. Index आहे दुसऱ्या पानावर. And then there is certain chart C which is of important judgments on cash bail, how guidance is issued by Supreme Court to various magistrates. Those are the chart. Chart D मध्ये आहे how promise to marry and then not able to marry and having sex or relationship, how it is not rape. त्याच्यात ABA किंवा bail साठी असेल, which is of course sessions court, त्याच्यात सुद्धा भरपूर judgments मी दिली आहे, relevant important judgments. There is another chart of POXO in which there are judgments of bail or ABA. In fact, one judgment of Bombay High Court is that a girl who was 14 years old, she was taken to 3-4 different places by 2-3 people over a period of several months, and the court has observed that yes, she knew what she is doing, and it is implied she had given consent. 14 वर्षाची मुलगी आणि म्हणून त्या आधारावर त्याची कन्सेंट व्हॅलिडेट करून त्याला बेल दिलेला आहे, अशी पण एक जजमेंट आहे बॉम्बे हायकोर्टची. It is not challenged by the prosecution in Supreme Court, so it remains the binding law now. That judgment is also there. I'll give you that. I'll tell you where it is. Then there is a chart F, which is about dowry cases usually, which is that स्त्रीधन रिकव्हरीसाठी किंवा कशा हे सगळ्यासाठी कस्टडीची गरज नाही. Usually some cases there are genuine cases where women are thrown out, but usually most of the cases any amount can be put, and these days all the cases are usually before coming to FIR they go to a lawyer and consult काय टाकायचं FIR मध्ये, and pattern usually same च असतं. Earlier it used to be like dowry cases म्हणजे लोक घाबरायचे. After Arnesh Kumar judgment, that fear is little gone away. So now sometimes there is a this thing about adding 377 IPC in that usually. So that 377 IPC बद्दल पण काही judgments दिली आहे, how to deal with that and bail if the cases are genuine and false cases. So that is one thing. Now I will, before touching the chart, I will explain you the concept of bail, because once you have that concept of bail, then you know how to deal with that. So आपण bail दररोज घेतात. We apply for bail every day. Every person who is arrested, we have to apply for bail or even anticipatory bail. Bail is a concept. Incidentally, it is not defined in any law, neither in CRPC, neither in IPC, neither in Constitution, nor in Evidence Act. But still we take bail, though we don't have that bail word anywhere defined by the Parliament in this law. Bail is not defined in any statute excepting in the dictionary. That's all. कॉन्ट्रा ऍक्ट मध्ये आहे बेलमेंट म्हणून, त्याच्यावरून आपल्याला निष्कर्ष निघतो व्हॉट इज द मिनिंग ऑफ बेल. म्हणजे कोणी कोणाची गॅरंटी घेतली किंवा जामीन घेतला किंवा आश्वासन दिला की हा माझ्या वतीने येणार, so that is kind of interpretation which is there, but that bail is being taken every day. So now what is the purpose of bail and custody? Any person is arrested. I'll not go by statute or sections to make it academic or your exam type boring lecture nahi karna hai. I'll explain to you to the point. Person is arrested depending on the sections. These days nobody is arrested without 41A. म्हणजे ते 7 वर्षाची असेल तर पोलीस आर स्केड टू टच unless there is some vested interest of the police. म्हणजे कोणाला त्रास द्यायचा असेल किंवा ह्युमिलेट करायचं असेल तरी करतात, अटक करून टाकतात sometimes. So whenever a person is arrested and brought over here, the question arises whether it has to be going for remand or it has to go for custody. The purpose of custody is only for 2-3 purposes. म्हणजे 3च ग्राउंड असले पाहिजे तुमच्या रिमांड ऍप्लिकेशन मध्ये, नाहीतर पोलीस इज नॉट एंटायटल. वन ऑफ द मेन ग्राउंड इज अंडर 27 एव्हिडन्स ऍक्ट मध्ये काही फिजिकल रिकव्हरी करायची. म्हणजे कोणी कोणाला चाकू मारला किंवा चेन खेचून घेतली तर रिकव्हरी हॅज टू बी डन, नॉट कॅश. म्हणजे कोणी पाकिट मारला 500 रुपयाची किंवा 2000 रुपयाची कॅश रिकव्हरी आहे, दॅट इज नॉट अ व्हॅलिड मच स्ट्रॉंग ग्राउंड. तो वन इज रिकव्हरी. जर रिकव्हरी पोलीसच्या रिमांड मध्ये किंवा ते ग्राउंड मध्ये नसेल, देन कोर्ट कॅनॉट कन्सिडर इवन ॲट प्रायमा फेसी फर्स्ट डे ऑल्सो कोर्ट कॅनॉट कन्सिडर द रिमांड इफ देर इज नो व्हॅलिड ग्राउंड मेड आउट. जस्ट बिकॉज पीसी पाहिजे पोलिसांना आणि इट इज अ नॉन बेलेबल ऑफेन्स आणि अटक करून आणलाय म्हणजे ते बेल द्यायचा किंवा जेसी नाही करायचा, दॅट इज नॉट परमिटेड. नॉर्मली व्हॉट वी डू एव्हरी डे इज जेसी जिथपर्यंत झाली नाही तिथपर्यंत आम्ही लोक बेलसाठी बोलत नाही कोर्टात. That is a trend and that is fair also, not unfair to the prosecution, and court is also fairly not entertaining an advocate for bail at that stage. But there is a way out for this also. So whenever a remand application comes, first you have to see custody साठी कशासाठी पाहिजे custody. Whether you want to recover something under 27 Evidence Act from possession of mine, then yes. Whether he wants to say that I am from some Daud gang or Gawli gang आणि मला मोकळा सोडला की हादरा बसणार, आणखी लोक घाबरतात, एवढी दहशत आहे माझी की लोक पोलिसांना तपास कमी मदत नाही करणार, then possibly yes, then they have to show that background की yes I have this antecedents, गोळीबार केलाय, कोणाची हत्या केली आहे किंवा अटेम्प्ट टू मर्डर केलाय किंवा अपहरण करून गँग रेप केलं की काय बॅकग्राऊंड असेल असं दहशत निर्माण होऊ शकते माझ्यामुळे. दॅट इज सेकंड थिंग. थर्ड थिंग इज विच इज युजली बाय पोलिस, यांना बेल दिला किंवा पीसी नाही दिली तर ते पडून जाईल आणि आम्हाला पुढे कामासाठी मदत नाही. So these are the only 2-3 grounds. That third ground is also after PC is over, not before that. But 2 grounds are made. Whether you will interfere with investigation or the witnesses and all that, then yes. Then you have to ask a question to the court. what is the investigation which they cannot do without taking me in custody or without continuing my custody. Is there any ground made out that त्यांना custody नाही दिली तर ही अमुक 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 तपास शक्यच नाही, then possibly yes, custody is justified by the police. Till that time, no. So you have to have basically on two things. There's nothing is made out where it will interfere with the investigation or I will tamper or hamper with the witnesses. Merely saying is not enough. प्रत्येक अर्जीमध्ये पोलिसचा ग्राउंड असतो. याला मोकळा सोडला की ही हॅम्पर विथ विटनेस, टॅम्पर विथ विटनेस किंवा विटनेसला इंटरफेअर करेल, तपास कामी दखल देईल. So that is merely saying is not enough. That is there dealt with in Supreme Court judgment I have annexed here with also. So that is one aspect. Second aspect is, first aspect was recovery. So if recovery is not shown, then again that is a good case for bail. Now this is at the stage of bail. Correspondingly, there is a ground for anticipatory bail. It is a different ground and a more wider ground. Anticipatory bail मध्ये पण असं आहे की there are cases where usually what police says, साहेब forgery cheating चा केस आहे, 10 कोटी 5 कोटी cheating झालेली आहे, तुम्ही custody द्या PC. But you have to see what is the ground for PC. Merely because allegation is forgery, allegation is cheating, or allegation is of 5 crore cheating, that is not sufficient to grant PC at all. How not sufficient? Is that firstly you have to look at what is the forgery done. Whether forgery document is recovered by the police or it is in public domain and available to the police to recover, whether it can be recovered without my custody, then my custody is not required. Number two, whether the police is saying that any document is recovered, but then they want to see who did the forgery. Again, custody is not required. At the most, you have to take my samples of signatures that I am willing to cooperate. You put me to condition, and that is there. या सगळा जे मी मुद्दे मांडतोय ना तुमच्या समोर, सगळ्या मुद्द्याबद्दल मी जजमेंट ठेवलेली आहे. आणि त्याच्या इंडेक्समध्ये टॉपिक वाईज आहे, कुठला टॉपिक आहे, पॅरा नंबर कुठली आहे, पेज कुठलावर आहे जजमेंटची, ऑल दिस आर देयर. देयर आर 3 बिग जजमेंट्स विच आय हॅव नॉट अनेक्स फुली, म्हणजे ते लय जाड होत होता. त्याच्यात मेन जजमेंट एक आहे, पहिली जजमेंट आहे गुरबख्श सिंग सिबिया, which was a very old judgment of 1980. म्हणजे landmark judgment which is followed by Supreme Court even today. This was a Supreme Court judgment where anticipatory bail law was later on crystallized and more amendments were made. That is sufficient to show. पहिली judgment आहे, page number 1 to 13 आहे. I'll read that para. तुम्ही index वर गेले ना, this is the page A of the judgment chart. Compilation. Chart मध्ये गेले तिथे पण आहे. We can go with the chart only if you don't want to turn the pages. We can go to the chart also. Same thing. Only thing that para number चा पान सुद्धा आम्ही त्याच्यात जोडला chart मध्ये. Which para number is on which page? ते additional जोडून दिलाय. So this first para I will read out. It is very important. It is of paramount. This is Supreme Court. It was a full bench judgment. It is of paramount consideration to remember that freedom of the individual is necessary for survival of the society, as it is for the egoistic purposes of the individual. A person seeking anticipatory bail is still a free man entitled to presumption of innocence. He is willing to submit to the restraints of freedom by acceptance of conditions which the court may think fit to impose in consideration of assurance that if arrested he shall be enlarged on bail. म्हणजे it is our first right to be presumed that I am innocent till I am convicted, till by the Supreme Court itself. Till that time I am presumed to be innocent. There can be no presumption that wealthy and mighty will submit themselves to trial and that the humble and the poor will run away from the course of justice, any more than the presumption can be that the former are not likely to commit a crime and the latter are more likely to commit it. म्हणजे magistrate or court cannot assume that just because he is a poor man, he will run away, he will not be available, or he will do more and more pickpocketing just because he is poor, or he will do more chain snatching, or he will do more dhandalgiri, that he is not allowed to presume. And this is not what I say. This is what the Supreme Court full bench has said, and it is binding law on the magistrate. Now, often we have seen, before I proceed to the next judgment, this problem must have been faced by some of you, that despite the fact you give a judgment, the magistrate says, the facts of the case are different, I reject your ABA. असं भरपूर वेळ झालेला आहे. I used to experience it in my initial years of trial. But when you make an application, you have to make it with annex, if you can spend a little from your pocket, Annex a copy of the judgment as Annexure A to it, reproduce that relevant para, and in the prayer also say, in the light of binding directions of the Supreme Court, in this para, in this judgment, you are now requested to kindly enlarge the person of antecedent bail. So then the judge knows that now it is my skin against the Supreme Court directions, and I should not dare to disobey the direction, because you are putting that ground in the that para number and the judgment citation in the prayer. So then it is impossible for him to take a risk, because if you then go to High Court, then there will be strictures on the because he has to give reasons why he is discarding that paragraph, that prayer. So then it will be very difficult for him to explain why he refused to give a reason of rejection against that judgment. That is one way. Before I go ahead, I'll tell you about the JC and a PC baddal. When a person is produced in JC, usually magistrate says, sorry, जिथपर्यंत JC होत नाही, तिथपर्यंत तुम्ही bail टाकू नका, and usually it is not considered also. So we should make an usually or application if you feel it's a fit case from the remand application in the FIR that no PC is required further and police is inclined to take it and magistrate might consider it, then you should possibly make an application. Don panachi application. Sir, these are the grounds the 27 Evidence Act is not made out. It is not the case that I am a terror who will intimidate the witness. No meaningful ground is made out. The ground मध्ये टाकतात ते interfere करणार आहे ते पडून जाणार ते पण टाकतात. He will not run away. His permanent address is here. Documents are annexed. Police had the residence address. That's why they arrested them from there. FIR मध्ये असेल तर otherwise annex some 2-3 documents, Aadhaar card, ration card, and say this is available. So there is no need for JC also. Application केली आणि त्यांनी VPच्या से घेऊनच रिजेक्ट करावा लागेल. जर केला रिजेक्ट, he has to give reasons why is rejecting. He knows that if you go later on to sessions or high court for bail against that person, then you will add this also that time. And then high court is not going to, or session court is not going to spare that application's reasons if they are not clear. And no magistrate or a session judge likes, or even a high court judge likes, that a superior court should find my reasoning bad in law or might pass a stricture against me. So nobody wants to take the chance, provided you put everything in writing with a judicial prayer. Once a judicial prayer is made for not giving JC, he has to pass a judicial order with reasons dealing with your grounds over there. So that is the stage when usually magistrates think twice before giving PC, and they are very sure then they have to give reasons why your judicial application for a judicial order not to give JC was rejected. So that is the thing. If you are willing to take a risk of, willing to take extra effort of putting that application at that stage, then entire scenario will change over a period of 2-3 months. Magistrates will have to think twice before merely on oral request or remand application giving a PC, because we don't put anything in writing. Secondly, must at every stage keep one format application ready if the police does not give a copy of remand application. Magistrate has not got a right to hear unilaterally, but he has to pass an order with principles of natural justice, that is by hearing the other side also. म्हणजे दोघांची ऐकली पाहिजे मॅजिस्ट्रेट साहेबांनी. And to hear the other side, you cannot be heard until you know what is there against you in the remand application. So remand application has to be given to you, and if it is not given, magistrate says I'll not tell the police, and police म्हणणार आम्ही देत नाही, PP म्हणणार मी देत नाही. That is not the end of the road. You have to keep a format ready, sir. Before you pass order, let that application be furnished to me. Pass an order to furnish application. एक format बनवून ठेवायचा आणि टाकायचा. Sir, before you hear that application, their remand application, hear this. Then if he rejects, then he knows it is not principles of natural justice and it is not a proper judicial order of rejection. So it will be difficult. And if not today, काय लोकांना असं वाटतं की वकील साहेब काय इकडेच प्रॅक्टिस करतात, कुठे सेशन हायकोर्ट पर्यंत जाणार, रिजेक्ट केला. It is not easy. They know that tomorrow somebody will go to session, that material will be compiled and connected in that thing, and that time it will be difficult to explain. So it is not very easy to reject that. And I personally feel, I have seen, I have appeared before Supreme Court regularly in very challenging matters. In one of the matters, I'll tell you example before I tell you what I'm about to tell you. It will change your mindset towards the judiciary and all. I had gone in this vacation on 2nd June this year, last year, to get payroll extended in a murder case, who had jumped payroll and not gone to court after his COVID payroll ended. And I had said I want 2 months extension. The Supreme Court said, sorry, it will be a precedent, everybody will jump over here and come here. What is the section 302? What is the punishment, sir? Life. Weapon, firearm. Prime accused. Rejected, thrown out. I called the client in the courtroom that time. So I felt a little sad. Next matter called out, proceeded. I felt a little bad, I turned around. Supreme Court is very, very dangerous to mess around with. You can't mess around wrongly. So I told, sir, may I with permission intervene? And with apologies to the prosecutor and the lady who's arguing, whose petition is there. There's something, one moment I'll take only, just very urgent. I had one AOR. तिथे काय AOR ची पद्धत आहे. Advocate on record is a post who is having a Supreme Court exam passed and all, and then you can file through them. तो घाबरला की बाबा डिसमिस झालेला आहे, तुझा दुसरा कॉल आउट झाला, युअर इंटरफिअरिंग. तो माझा हात पकडून असं सांगतात, प्लीज डोंट गो बॅक. I went and I said, there is one moment I want kind indulgence. बोला, yes, we have dismissed your petition. बोला, sir, one moment only. बोला, okay, Nagrata madam थी, or it was, I think, Brahman or somebody was there that time. So, Nagrata madam is going to be a Chief Justice for a short while later on. So, I argued the matter. My office team was online also, watching it online. So, I told him, sir, one only request I want. I don't want any extension of time. Now he has jumped the payroll, not surrendered also on time. 224 IPC FR होता automatic, you have jumped custody. So I had to save him from that. So I told the court, sir, kindly give me just 2 weeks time to surrender. Okay, 7-8 दिवस दिले त्यांनी. Okay, paper मागवले, yes. The other side was told to hold and all. Everybody was shocked. How can a dismissed matter, another matter called out, again taken on board, again that order passed, immediately order passed. I was happy. I went to the canteen and there everybody complimented me, how you did daring. आमचे दिल्लीचे वगैरे एवढी daring करत नाही त्यांना दररोज होते. But before I left the courtroom, I was very grateful, sir. I really am apologetic. And असं बोलून मी निघत होतो. So ते दोन्ही जज मला बोलले individually. My team was there online watching it. Mr. Counsel, today we have learned something new from you. And despite we wanting to reject it, you have snatched the order and given relief to your client. No, sir, he would have suffered 224 IPC. That was my desperate attempt to save. Well, yes, we have given, but we are learning new things, how advocates are skillful to, despite rejection, overcome an order and get something else. You got the order, but in a different manner. So I said, no, sir, it is me who has learned from you that, I should have not intervened. No, that's okay. Madam Pad boli. Mr. Counsel, we learn every day from advocates like you. It's a new thing we have learned, but it is good. I saw compliment Dilan, and I was so elated. This is not an example I give you to flatter myself or show off about me. Now I want to tell you what you people are. Each one of you is equivalent to Mahesh Vaswani. How and why I'll teach you just now in a moment. Every judicial officer and magistrate comes to the court with the hope that today I will learn something new in good arguments. So everybody is married, most of you over here, and everybody must have had children. Every child must have from your family gone to school. You must have taught him KG class, first standard, सब पढ़ाते हैं. आप नहीं तो wife पढ़ाती होगी, आप भी कभी पढ़ाए होंगे. So you have to be ready mentally, treat the magistrate like a child who is ready to study. Be so well prepared with the syllabus of what you are going with, and try never to go without a judgment on the subject. Today I am going to ample judgments. I'll take to you point wise on what topics they are. So go so prepared that magistrate should not bother to look at kiti ved dhalabni tumi kai zala. He should be ready to give you order by listening to you, and he wants to learn more once you point out judgments. Because every magistrate, every session judge, every high court judge has at the end of the month by 30th or 31st, he has to send a report of monthly progress of what all matters he has disposed of. President Saibana माहित असेल. So they have to give a progress report काय काय डिस्पोज केलाय of good matters. कुठे रिजेक्शनच्या फालतू ऑर्डर केलाय किंवा अनरिजन केलं ते जात नाही वरती. जे चांगली कामगिरी आहे ते पाठवतात. And based on that, their appreciation of confidential report and promotions are also, that is considered at that time also. So when you give them good reasoned judgments and they pass a good order, they like that advocate first because they want that order to be sent to High Court and Sessions Court, and Session Judge will want to send it to High Court and superiors. High Court judges also want that somebody comes with judgments and argues, so then we can send it to Supreme Court to show what all reasoned orders we have passed. So that is a thing you should keep in mind, that to get relief to your customer is one aspect, getting properly prepared and leaving no room for a judge to pass an order against the judgment which you are citing, should be so much prepared, and judge likes to hear such advocates. And it is that judge will then always want, like kaitari judgment 2-4 टाक, माझी report चांगली जाणार at the end of the month, and I will be happy to listen to it. He will give you wide listening. So that is how face value becomes, not merely because सोलाने साहेब आज माझा मित्र आहे, उद्या सेशन जज किंवा हायकोर्ट जज झाले, आणखी मी गेलो तर माझी फेस व्हॅल्यू चालत नाही, 1-2 दिवस चालणार, पण त्यानंतर आय हॅव टू आर्ग्यू ऑन मेरिट्स अँड प्रिपेअर्ड लाईक अदर्स प्रिपेअर, ओपन कोर्ट आहे ते. So this is the background you have to keep in your mind, that you are going to a court. Everybody wants to listen to you, and if you are better than him in your arguments and submissions, you have to be citing the law to him, and that law which you will require for all your matters in this court. I think I have given judgments on all topics whichever you will need in magistrate or sessions court, excepting some special laws, म्हणजे anti-corruption, SC, ST and कुठला 353, 332 त्याच्यावर अजून नाही दिली मी जजमेंट. So it was very wide. Initially साहेबांनी मला रिक्वेस्ट केला होता एव्हिडन्स ऍक्टवर, which is my favorite subject, but I didn't want to come only for a lecture and bore you people. I wanted to come prepared like this. त्याची तयारी चालू आहे अजून. Next lecture sometime later will be on evidence act, which will be such that none of you will ever conduct a trial where the prosecution should succeed. Every matter you will be able to succeed. एवढी तयारी करून जाणार तुम्ही. Now let us deal with this bail applications. I'll deal with the subject chart, para-wise. First was Gurbakh Singh Sibia. Chart number 2 is Bhagirathi Singh, Mahipat Singh Judeja. It is of 1983 judgment. Yeah, judgment मध्ये असा आहे, even if a person has committed a crime and it is prima facie seen he has committed a crime, still the rule is that he should be the last line of front page. Trend today is that towards granting bail, because now it is well known settled by category of judgments on this court, that the power to grant bail is not to be exercised as a punishment of before trial is being imposed. The only material considerations in such a situation is whether accused will be readily available for his trial, whether he is likely to abuse discretion granted by tampering, by tampering with evidence. But this is a Supreme Court judgment on a very serious offense of forgery and भरपूर sections होते. त्यानंतर there is another judgment of Bombay High Court. This is an unreported judgment. I have produced that judgment along with its typed copy, I am sure. No? It was a 1988 judgment. It was a forgery cheating case where they say arrest can ruin reputation. In forgery cases, documents will speak for themselves. Men may lie, but documents won't lie. When documents are available for investigation, no custody is required. So this is another landmark judgment of Sham Bhatia versus State of Maharashtra, which I have annexed here with. And the जुनी judgment आहे, certified copy आहे, पण ती clear नाही म्हणून type copy पण जोडली आहे त्याच्यात. You can annex both of them and give them. Then again there is third is of Joginder Kumar. That is again important, para 31 and 32 आहे, para 20 आहे, which says it is again a 1994 judgment. It is Supreme Court. No arrest to be made merely because it is lawful to do so. म्हणजे मी गुन्हा केला असेल, अटक झाली पाहिजे, but because police has power, it is not needed that अटक झालीच पाहिजे. पुढे म्हणतात सुप्रीम कोर्ट, it would be prudent for a police officer in the interest of protection of constitutional rights of a citizen and perhaps his own interest also, म्हणजे त्याच्या स्वतःच्या इंटरेस्ट साठी पण आहे, that no arrest should be made without reasonable satisfaction. Denying a person liberty is a serious matter, except in heinous offences, an arrest must be made. An arrest must be avoided if a police officer issues notice to a person to attend station house and not to leave without permission would do. म्हणजे ते 41 जे आता आलेलं आहे नोटीसच्या, ते आताच्या नाही, ते 1994 पासून आहे. ते नोटीस दिला तर that is sufficient and arrest is not required. And once you put this judgment in a bail application or annex it with the relevant para typed in your memo of the bail application, then it is very difficult for a magistrate to reject Supreme Court's binding guidelines, I feel. Not even session judges. I have seen in best of the cases that paras are very important. So then there is another judgment, similar one. It is judgment number 5, State versus Anil Sharma. The High Court, this is a case where learned single judge, second line was to me, single judge of the High Court reminded himself of the principle is that it is well settled that bail and not jail is the normal rule, and then observed thus, unless, this was a High Court order which was challenged in Supreme Court, and High Court said bail is a rule, not jail. But then what High Court observed, unless exceptional circumstances are brought to the notice of the court which may defeat the proper investigation, and bail to a person who is not accused of an offence punishable with death or imprisonment for life. In the present case, no such exceptional circumstances have been brought to the notice of this court which may defeat the proper investigation to decline bail to the applicant. म्हणजे हायकोर्टाने काय उल्लेख नाही केला होता असा, it had not pointed out which circumstances are there. So it has not necessary that merely grounds of the prosecution has to be taken, but why the bail should not be granted, that reason has to be given. Not merely because police is asking and that is sufficient. No. What exceptional circumstances are there where bail should be refused, that has to be given. म्हणजे ही पॅरा पण तुम्ही रिप्रोड्यूस केली, then it will be very difficult for magistrate to give an order without dealing with this paragraph. But you have to take the trouble of not tendering judgments. It doesn't go on record. You have to annex it in your application as annexer A, B किंवा J तुम्हाला योग्य असेल judgment त्या, and put it in the prayer as per judgment cited in para so, citation so and so of so and so. ते prayer मध्ये टाका. In light of this, now grant bail. असं टाकायचं. Then it is very difficult to pass an order that why he rejected that judgment which is mentioned in the prayer also. Then there was, of course, it's a landmark judgment, 6 number or Sidharam Mehta, everybody must be aware of, but I have annexed the, he like jar judgment hoti, म्हणून मी full annex nahi केली आहे, but the relevant para and page numbers we have annexed with front page, last page and that para numbers, where guidelines are made. Again, that earlier judgment of Jogendra Singh is reproduced here. No arrest should be made because it is lawful for the police officer to do so. The existence of the power to arrest is one thing and justification for exercise is quite another. The police officer must be made to able to justify the arrest apart from him doing so. This finding of the said judgment surprised contrary to the legislative intention of and law which has been declared by the Constitution bench of this case in Sibia's case. Again, Gurbakh Singh Sibia is reproduced here. This Sidharam Mehta's case was a case where the Home Minister of Maharashtra was prime accused in a murder case where a rival candidate was shot dead by him. Sidharam Mehta was a state home minister in Maharashtra. He was applying for anticipated bail. It was rejected. It went up to Supreme Court. He was granted anticipated bail. And what is the observations and guidelines laid down by Supreme Court? It is there inside. We have reproduced that in the judgments. There are 12 guidelines. What are the important guidelines? If you cite those guidelines in ABA, sir, Supreme Court says murder मध्ये ही guidelines लागू करून ABA देतात. साहेब माझ्याकडे तर मर्डरचा ABA नाही. Usually we don't go for murder cases in ABA unless it is a very pressing case. Client is insisting, that is different. So it will be very easy to use this judgment. If you annex it, it is a very thick judgment, 70-80 pages kaitari SLA, depending on which website you go for. Then there is another judgment of later on another judgment came in 2012 was Sanjay Chandra versus CBI. Now this judgment is usually argued by every advocate orally. And sometimes even we take the trouble of tendering, म्हणजे त्याला xerox करून 2-3 सेट काढा गेले ते 200-300 रुपये आपले खर्च होतात, because it is 70-80 pages or 100 pages depending on the website where you're getting it from. But then in that it is worthwhile to annex that judgment, reproduce that paras in the body. Para 21, 22, 23 are important. I have annexed that judgment and the paras here. The courts, para 21 I'm reading. The courts owe more than verbal respect to the principle that punishment begins after conviction and that every man is deemed to be innocent until duly tried and found guilty. He should be, next para hai, he should be deprived of his liberty upon only belief that he will tamper with witnesses if left at liberty, save in the most extraordinary circumstances. Third para hai, 23. Apart from the question of prevention being the object of a refusal of bail, one must not lose sight the fact that imprisonment before conviction has a substantive punitive content, and it would be improper for any court to refuse bail as a mark of disapproval of former conduct, whether the accused has been convicted for it or not, to refuse bail to an unconvicted person for the purpose of giving him a taste of imprisonment as a lesson. Means, unless the court has a reason to give that why he is giving custody, how he will interfere, फक्त police म्हणतात he will tamper with evidence is not sufficient to reject the bail. He has to cite practically how I will interfere with bail or with the evidence. So unless that is cited, that can be dealt with by conditions which can be imposed. Then there is another judgment, Bombay High Court, serial number 8, where this is very important for forgery cheating cases, sir. Actually, this was a judgment where I had personally argued this case. It was a case where family dispute, sister is a complainant, brother, his wife and brother's in-laws are all accused. There were 7 forged documents. FIR was about 10 crore rupees of property cheating and forgery. Wills, gift deeds, power attorney in the bank, journal power attorney, all were forged, 7. And ABA was rejected by Sessions Court. All documents are available in public domain. Before ABA, we went to High Court. We also put the balance documents in custody of the police. The entire thing was argued, and then court came to a conclusion in para number 20 that prima facie it appears that there is all these documents are forged, because the ज्याची forgery केली होती त्याचा वडील होता, complainantचा आणि त्याचा भाऊ होता, and he was in dementia for those period 2-3 years. ते सही करू शकत नव्हता, समजत नव्हता, according to medical reports. And then all documents are forged. Prima facie it is made out that it is forged. Still, I argued, sir, rubber stamp forged केले, will forged केले, सगळं मान्य करा. Let us assume. Why custody? What is the investigation that cannot be done if I am not in custody? There was no answer. तुम्हाला डॉक्युमेंट इन्व्हेस्टिगेट करायचे, मी केली आहे, कोणी केली आहे ते बघायचं ना, सही आम्ही देतो, विल कोऑपरेट, बाकी काय करायचं. So then court had no option. It observed that yes, despite forgery having been committed of 7 documents, 10 crores worth of assets are there involved, still anticipatory bail was granted to 5 in that case. So that is a landmark judgment, serial number 8 for forgery cheating cases. Kadi ABA साठी गेले ना तुम्ही, so you can use that. That relevant paras are mentioned over there also. And then, sir, later on there is Amanpreet Singh. That is a serial number 9. Is Amit Anandpai Raikar. Sorry, 9 number is Amit Anandpai Raikar. This is again a reproduction of Bombay High Court judgment. This is a Bombay High Court judgment which is followed the earlier judgment of Bhagirathi Singh Judeja, which is at serial number 3 it was, I think. No, sorry, Bhagirathi Singh Judeja, serial number 2. So this case of Goa, then is again a good case for anticipatory bail. This is a case where forged currency was seized. All the sections of forgery, cheating plus bogus currency were applied to it. The Goa bench of the Bombay High Court says custody is not required. Material is recovered. Investigation can go on without custody. So it was granted. So these are landmark judgments 8 and 9, where you get forgery, cheating documents or allegations, and where you can use them for getting ABA. If documents are already available to the police, or if they are with the banks or somewhere where police can recover, then the applicant's custody is definitely not to be permitted. And once you cite this Bhagirathi Singh and this 8 and 9, serial number 2, 8, 9 for forgery cheating, that should be very easy for you to get bail. And you can add whichever you like other than that also. Then there's another thing that charge sheet झाली आहे, आणखी अटक नाही झाली होती तिथपर्यंत. Then it is not necessary to produce the accused with the charge sheet. That was somewhere in serial number 10. In forgery cheating cases, sometimes they investigate without arresting you. आणि कोर्टात गेले आपण तर मॅजिस्ट्रेट मध्ये टेक नाही, तुम्ही कस्टडीमध्ये जावा, तुमच्या शोटी व्हेरीफाय होईल, हे होईल, ते होईल. So it is not necessary that they should put you in custody on the day of charge sheet, because you have to come to court sometimes. Or even if at a later stage you come to court, sometimes they take you in custody. So you should not panic. This is the judgment which will help you. Then there is, this is another at serial number 11 is a Hemant Hathi versus CBI. This is a case, this will be usually for ABA. This is a case of forgery and cheating. Hundreds and thousands of people were cheated. 1500 कोटीची cheating झाली, 1500 crores. And out of which the person said, I am willing to deposit, he is abroad. He is willing to deposit the entire amount. Today he says I'll deposit 900 crores and rest I'll deposit. Give me bail. Sorry, it was a bail case. You give me bail. So Supreme Court prosecution objected. Supreme Court said no, ABA can be granted in these kind of cases. So this is another landmark case. Some cases where people have taken money bona fide. I am a builder. I have taken money. Suppose your client is a builder. He has taken money for building construction. Some problems happened, some litigation happened, and he could not complete. SRF project forgery, cheating, MPD सगळे लावून टाकतात police. So in such cases, if he is having the money and if he is willing to deposit in the court to save his skin, so then court should consider such things and save the money of the investors and allow the work to go on and not take him in custody. So that is a good case.